So, self-defence and the prevention of crime. These are two separate defences. However, the handout deals with both defences as the same defence effectively. Why? The test for both is almost the same and the case law is identical. Indeed, some of the cases which apply to self-defence also apply to the prevention of crime as well. So for our purposes for the criminal law exam, self-defence and prevention of crime are effectively the same defence. So as we go through the handout, as we do in class, just make points of annotation, explanation, sometimes points of AO2. So for the purposes of our exam, not necessarily the real world context, self-defence and prevention of crime tend to be defences for the non-fatal assaults, i.e. the assaults against the person. So English law allows a person to utilise reasonable force in two main situations: self-defence, prevention of crime. Self-defence being defence number one, prevention of crime number two. So the difference between the two, just note at the side here the difference between the two. In short, self-defence, D is using force, committing an assault to protect himself, i.e. in the title, self-defence. Prevention of crime, D is using force to utilise that in the prevention of crime, or another way of looking at prevention of crime, often using force to protect others. So self-defence, protecting self, prevention of crime, protection of others. So self-defence has always been a purely common law defence. As ever, with many areas of criminal law, that means it's come from the courts, the House of Lords, Court of Appeal, rather than Parliament defining the defence. Prevention of crime is governed, however, Section 3 Criminal Law Act 1967. So that's always been a statutory defence. And under that Act, it stated that a person may utilise force as is deemed reasonable in the circumstances in the prevention of crime. Now, both of these defences were picked up very recently, or relatively recently in criminal law in 2008. So both were codified into Section 76 of the Criminal Justice and Immigration Act 2008. Now, this could well be an essay, so we do need to know AO2 as we're going through the handout. So first point to note that Section 76 made no attempt to address any of the AO2 critical issues attached to either defence. So especially self-defence, there are lots and lots of problems. And where the problems arise, there are quite serious problems within the defence. Section 76 was merely a codification exercise. Therefore, it was bringing the information together rather than attempting to address any of the issues. Right, so moving on. The defendant will have a defence for both defence of self-defence, which you can call brackets SD, and the prevention of crime defence, POC, if he used two things. Number one, necessary force, and number two, reasonable force. Now, those two words connect to the two-part test. The word necessary indicates part one. Necessary means subjective. Necessary to D, subjective to D. So wherever on the handout, just add on there, necessary, subjective. The second important word is the word reasonable. Reasonable force. We've used that word loads and loads this year. Reasonable is an objective word. So that is reasonable force according to the jury's foresight perception. So necessary is subjective, reasonable is objective. Just on a point of procedure, once the defence has been raised by the defence, i.e. D says, yes, I had to use force, that X was coming towards me with a knife, he just needs to make that allegation that self-defence was needed. The burden of proof then lies with the prosecution to show that self-defence was not there. Either it was unnecessary, or it was unreasonable, or both. So the test. So this is the test in a little bit more detail. So for both defences, POC or self-defence, SD, you've got a subjective and an objective element which apply. So number one, did the accused or defendant honestly believe he had to act in the way that he did, i.e. was the force necessary to him in self-defence or prevention of crime? So part one is a subjective test. Was it necessary, whether it's PRC or whether it's self-defence SD, was it necessary, honest to D? Part two, was the degree of force used reasonable? So that test is objective, completely at liberty for the jury to decipher. Objective. Right, so if we just proceed through the subjective test, then we've got various characteristics which apply. And actually, as we go through these, we'll see that actually self-defence is quite generous on D. So most of these are quite making the defence quite easy to satisfy, to prove. So, which can be good PP, it can be fair on D. We'll see as we go through the case law. So first of all, in order to use the defence, the force must be justified and it must be deemed necessary to D. So however D is seeing the situation, foreseeing what the other people are doing in that scenario, they must see that force is necessary. Totally in his perception because it's subjective. Quite importantly, timing. The threat must be specific, so it can't be a vague threat. Well, I think X or Y might be doing X or Y. That's not sufficient, it has to be a specific threat. Who, what, why. But also, in terms of timing, the threat has to be imminent. So that's quite an important word. What do we mean by imminent? Well, you may well appreciate from the assaults, imminent has a different interpretation from the word immediate. Imminent, and make a note at the side, imminent is near future. Immediate is now, imminent, near future. So that's quite generous as well. However, again, more generous to D. D does not have to wait for the assailant to strike first. As long as the threat was anticipated, i.e. imminent to D, the defendant need not wait to be attacked, but must at least fear that it was about to be attacked. So this is called in certain circles a preemptive strike. Again, very generous, you don't have to wait to be struck first. But actually very good PP. If you're in a pub, or anywhere indeed, and somebody comes towards you with a knife, if that wasn't the case, you'd have to wait to be stabbed to intervene. Or if somebody came towards you with a gun, you'd have to wait to be shot before you could intervene. So the fact that you can retaliate before the action, the assault, actually takes place is sensible, reasonable, good PP. Right, so it also may be permissible for D to issue threats of force, even death threats, if it might prevent an attack upon themselves or a crime occurring. So that links to the case of Cousins, which is just below, so we'll go through that in a second. D may also be allowed to prepare for an attack. Again, very generous, allowed to prepare an attack as long as he fears or she fears that an imminent threat will take place. D is allowed to prepare for the next attack. And again, that links to a case AG's ref. Two recent additions to self-defence. The need for self-defence may be self-induced. Again, that's AO2, which means that D can start the confrontation. D can start the fight, but still then receive the defence. And finally, the assault used within self-defence may be aimed not at the person who caused the confrontation, but it could be any innocent third party. Another recent addition to self-defence. So looking at the case law then, cousins on part 1. So D believed that a contract had been taken out on his life. What that means, for those of you that are not aware, that a contract on somebody's life means that somebody's been paid a lot of money to kill that person's life. So as a result, he believed this contract had been taken out, so he armed himself with a shotgun and went to visit the man who had taken out the contract, his father, and threatened that he would blow his brains out. So he's utilising a death threat to counteract the contract that had been taken out on his life. So D raised the Section 3 defence, prevention of crime, which failed in the trial court because the trial judge said the threat was not immediate. So this contract that had been taken out on his life was not immediate. It wouldn't happen right here, right now. Near future, maybe, next few weeks, next few days, but he knew or did not believe that the contract would be carried out right there, right then. So this went on appeal to the Court of Appeal, who held that actually the defence could succeed as long as the threat was imminent to D, and D's act of retaliation was deemed reasonable as well in the circumstances. So let's just split that up into 2 different parts. Part 1 of the defence, was the force utilised necessary? Yes, it was imminent to D. He knew the contract had been taken out. He didn't know when it would be carried out, but near future tick. Part 2 of self-defence, was the degree of force used reasonable? Contract on life, death threat, balanced each other out. So we'll get onto reasonable force in a bit, but in short, knife against knife, reasonable force. Fist against fist, reasonable force. So you're looking at who has made the threat, what they're using, physicality, etc. So in short, in cousins, 2 things. Number 1, it was necessary and imminent. Number 2, it was reasonable force, death threat against death threat. Second case then, AG's Ref, number 2 of 1983. So this was it was the riots in 1983. So these riots, the defendant's shop and shopkeeper had been attacked and the shop had been damaged quite severely by rioters. So he feared that further attacks via the rioters would take place at any time. So he prepared some petrol bombs already in his shop, ready to protect his property if that was required. It was held that self-defence was available, so even though he'd gone to the extent of preparing the bombs, just in case a further attack occurred, the threat was held to be sufficiently imminent. Remember the test we just said above is not immediate. He didn't think it was going to be right here, right now, but near future. The threat to him was necessary. Part 1, tick. Right, Malnick, the next case on part 1. The defendant went to visit a man he believed had stolen his friend's car, so it was really absolutely nothing to do with him. His friend had had his car stolen, and so he goes round to visit the person who was suspected to have stolen the car. Now, the thief in question that he went to visit was known to be violent, and so D went armed with a rice flail. Now, that's a weapon they use in martial arts. Very, very, very dangerous weapon, implement to use. So it's a mixture of chains, wooden poles. It's just Google it. It's a very, very serious and violent piece of equipment to use. So he went round to visit this man who he believed to have stolen the car. Self-defence failed as the threat was not imminent, not even near future. It wasn't his car that was stolen, absolutely nothing to do with him. It wasn't immediate, it wasn't imminent near future, there was no threat coming towards D. D was choosing to get involved. D's car had not been stolen. He was choosing purely to help somebody else out and to sort out the theft of the car. So part 1 failed. And also actually, if you think about part 2, the force has to be reasonable. Reasonable, knife against knife, fist against fist. Use of a rice flail against theft of a car is excessive. So part 2 will have failed as well. So the defendant created the dangerous situation by choosing to visit the criminal. So you can see why self-defence would fail there. It was absolutely nothing to do with him. There was no imminent threat, it wasn't necessary, part 1, and it wasn't reasonable force in any event. Now, I've just put a question on the handout there in terms of identifying the difference between Cousins and Malnick. Because on first sight, it seems that both cases look incredibly similar. Cousins is going round to somebody's house to issue a death threat, and Malnick is choosing to go around to sort out a potential threatened theft of a car. However, they are actually, when you scratch below the surface, there is a key difference between the two. So just note this next to the question. So Cousins, what is the difference between the two? In Cousins, the contract on his life was imminent. So although he was choosing to go around to see this guy, the guy's dad, in order to prevent this contract being taken out on his life, he knew there was a contract, he believed there was a contract, and it was imminent to him. So you can see why he had to do it. He was going to die. Alternatively, with Malnick, yes, he chose to go visit the potential thief, but he chose to get involved. If he didn't do anything, nothing would have happened to him. There was no imminent threat. There was no need to use force, and also, as I said before, the force was unreasonable. So the key difference between the two is Cousins, it was imminent. Malnick, it was not imminent. So the next case is a rather recent case, 2010. Again, still on this point of part 1 of self-defence. So this was a house that was being burgled. And the burglars in question were utilising knives, they were armed, they were wearing balaclavas, so they were pretty much all tooled up. Now the family, which include the defendant, the family were told to lie on the floor and lie down, otherwise they would be killed. So that's a pretty scary situation. Gang of burglars come in, all armed with knives, balaclavas, and then you've got the family that are told to lay down on the floor or they will die. But at a certain point, then the burglars ran off. Yet the defendant, which is one of the victims, the defendant whose house had been burgled, and some other men chased them with a cricket bat, pole, which ended up in the fractured skull of one of the burglars. So the question was, could the householder be liable or would self-defence succeed? It was held that self-defence had to fail. The burglary at the point of the assault was over. At that point nobody was in danger, the burglars were running away. And therefore, to part 1 of the defence, the force was not necessary. It was not subjectively required. In fact, you could even add there that really that looks like revenge, which is not part of self-defence. It has to be an imminent threat. The burglary was over. Self-induced means that D started the confrontation in the first place, then V reacts, but D is still trying to rely on self-defence, even though he started the confrontation in the first place. So in the case of Key, D was charged with GBH when he punched the victim once in the face, a case of the single punch, albeit creating serious injury. So D had been the aggressor, provoking the fight and the confrontation in the first place. So he's trying to seek to establish self-defence, but he started the fight in the first instance. So, in the trial court, the trial judge held that self-defence would have to fail because the confrontation, the assault, was self-induced. So D appealed, and on the appeal, the Court of Appeal still dismissed the appeal, so D was convicted, however, created a rule for future cases, which was this. Court of Appeal held that self-defence could potentially succeed where the violence returned by V was so out of proportion from the original threat that self-defence could be established. I.e., just to elaborate on that point, if I went into a pub and insulted somebody, which means I am the aggressor, but then the person, the victim, turns around with a gun, I have then to use self-defence because that is a gun that is being presented to me. Self-defence could potentially succeed, even though I started the confrontation in the first place. As long as the retaliation is way out of proportion, self-defence is permissible. So the next case is the case of Hitchens, 2011. So, in this case, it was a male and a female who shared a flat. The defendant was the male. So he shared a flat with a woman, and the woman had a boyfriend. But the boyfriend was jealous that she lived with another man. So one particular day, the boyfriend of the girl was found knocking at the door. But the defendant, who shared the flat with her, feared the boyfriend would assault him. So as a result, slapped the girl, his flatmate, around the face, occasioning Section 47 ABH style injuries. So D raised self-defence, saying he had to do what he had to do, i.e. utilise force, in order to prevent an injury from him from the boyfriend outside. Now, the trial judge withdrew self-defence. The Court of Appeal, on review, withheld the defence and agreed with the trial judge and held on this particular occasion it was unnecessary for him to utilise force. I.e. really, whatever the boyfriend had done outside, there was never grounds for him to utilise the force against his flatmate, the female. However, again, a new rule was set for future cases. The Court of Appeal held in future cases it was possible that self-defence could give rise on the set of facts that we're looking at here, in this case, where force was used against an innocent third party. So again, all this is fairly generous. It's saying in future cases, even though you use force against an innocent person, as long as there's an imminent threat that could possibly succeed, just not in this case. Okay, the possibility of retreat. So this is a rule that used to apply, but today has gone. Now actually this is an illustration of the Court of Appeal developing the law and doing it in quite a good way, in that the rule was unrealistic from day one, and actually now it is more realistic and sensible in terms of self-defence. So possibility of retreat, under the previous common law, it seemed that the defendant or the accused had to show that he had tried to retreat back out from the danger and then had to retaliate. However, the courts have ruled that now today this is not necessary. This is not essential. Now, we could put some AO2 comments on this point. AO2, retreat was unrealistic in the heat of the moment. And furthermore, it would also mean that self-defence would fail most of the time. Why? What this rule is saying is that D has to stop the situation, back out, think about his actions, and then retaliate. Right, think about this example. You're in a pub and somebody is coming towards you with a knife. The possibility of retreat is suggesting you have to stop, ask the knifeman to think about it, go in a corner, consider what you might do, come back, and then continue the confrontation. That is not going to happen in a realistic situation. Or if you're in a house which is, for example, being burgled. The burglar's coming towards you up the stairs. Retreat means you have to think about it. You have to try and back out, and then you have to use self-defence or prevention of crime. Again, this is unrealistic. The phrase that tends to be used quite often is flight or fright. You don't have time to think about the situation. You just instinctively act as you think you need to do in the situation. So in terms of retreat, 9 times out of 10, D will not have the opportunity to think about it, to rationalise what he's doing, and certainly may not have the possibility of retreat. If a knife is coming towards you, you have to act. If a gun is coming towards you, you have to act. You can't think about it, you can't retreat. So again, it's an illustration of the Court of Appeal developing the law, changing the law, but it's good, it's a tick, it's good. So, the previous law was Julian, Court of Appeal. Now this is more for judicial reasoning purposes for an essay, but however, use it for that purpose. The Court of Appeal held that D, in any case of self-defence, to succeed with the defence, must demonstrate by his actions that he was unwilling to fight. So he has to back out, show that he didn't want to fight, possibly by making a physical withdrawal. Sounds sensible, but again, when somebody's coming towards you with a knife or a gun or a glass, trying to show a physical withdrawal is going to be very, very difficult. So, the criminal law today is Bird. Now, this was a house party. The defendant was celebrating her 17th birthday at a house party when her ex-boyfriend was there with a new girlfriend. So boyfriend and ex-girlfriend began to argue. Debbie Bird, the defendant, threw a glass of Pernod, strong drink, over him, whereby he went towards her and grabbed her by the neck. He slapped her, in return, grabbed her by the neck, forced her against the wall. Debbie Bird, the defendant, in retaliation, instinctively lunged towards him with a hand, and she had the glass of a drink in her hand. The glass broke in his face and caused him to lose an eye. So really what we're saying here is they're having this confrontation, he's grabbed her, pushed her against the wall, and she's acted with instinct and thrown the glass in his face. Now, initially, self-defence failed. Why? When she was pinned against the wall, she didn't retreat. She didn't think about it, she didn't retreat and walk away from the situation. So self-defence failed. However, on appeal, the Court of Appeal said that's completely unrealistic. Self-defence would succeed, could succeed, did succeed. It was not necessary from now on to show a reluctance to fight. Which is a really good decision. If you're being held up against a wall by a much stronger person, pinned against the wall, the last thing you can do is think about what you're doing, retreat, back out. You've just got to act. So self-defence succeed, and this was the case which removed the need for retreat. So good PP, good development by the judges. Okay, now we move to part 2 of the defence, which is the objective part 2 element of the defence. The accused or the defendant may only use force which is deemed reasonable. This is, as ever, a question of fact for the jury to decide, and whether or not the force is reasonable depends on the circumstances of the facts of the case. So in other words, you're looking for gun against gun, tick. Knife against knife, tick. But it would also depend about the person, so an elderly woman against a 6-foot young man may be able to use a gun against a fist. So it's all dependent on the circumstances, but again the jury have to balance up the threat and the retaliation that occurred. So where the force is reasonable, all or nothing, the defendant will be completely acquitted. So where it's a tick, where the force is reasonable, gun against a gun, tick, not guilty. However, if the force is held to be unreasonable or excessive, i.e. that D has gone overboard, he will be completely liable for the full offence. So like I just alluded to beforehand, it's all or nothing. Full assault, full acquittal. So a case which illustrates exactly that is the case of Private Lee Clegg. This was quite a local case, quite a sad case really. This was a defendant who was a soldier. So he was on duty in Northern Ireland, stationed at a checkpoint. So it was in the middle of the troubles in Northern Ireland, and at a checkpoint every car had to be stopped. So the job of the soldier is to check the car, stop the car, check passports, ID, things like that, etc. So this is a soldier who's on a checkpoint, and you can see a car racing through the checkpoint. Now, this was a few years ago, where joyriding, which is where people steal cars and go riding fast in other people's cars, very dangerous, was a major crime at the time. Maybe not so today, but it was at the time. So this car, which was identified to be a stolen car, came whizzing through the checkpoint. Now, Private Lee Clegg's job as a soldier is to stop that car from proceeding. Could be a terrorist, could be somebody dangerous. So Private Lee Clegg fired 4 shots at the car. The first initial 3 went through the windscreen as the car was approaching him, and the final shot was when they forensically looked at the ammunition, was as the vehicle had passed. A passenger in the car was killed, hence he was charged with murder. Now, when they looked at the forensic evidence, the round of ammunition that had killed Karen Riley, the passenger, was the final 4th round. The defendant ultimately was convicted of murder as self-defence failed. It was held that the victim had been killed by the last shot, which could never be self-defence, for 2 reasons. Number 1, the force has to be necessary and imminent. The 4th bullet, the danger had passed. The car had gone past him. So part 1 failed, in terms it wasn't necessary, it wasn't imminent. And secondly, the force was not reasonable force, part 2. Why? A car coming through a checkpoint versus somebody killing a passenger is deemed to be unreasonable and excessive force. So, in other words, D was liable for murder. Now, question AO2, how has that ruling been criticised? And again, as it alludes to on the handout, later there's a few more notes to add to this. Well, how has it been criticised? It seems massively unfair that in this particular case, nobody would disagree that D in his job had to at some point use self-defence. Yes, he's gone overboard, but D had to use self-defence. So first thing to note, a couple of things to note, but first thing, unfair on the defendant. Is in a position where he had to use force. The victim have stolen the car, and D is liable for murder. Murder attracting a mandatory life sentence. Also to add in that same question, for normal crimes, where the force is excessive, what the court can do is fail self-defence but give a lesser sentence. So let's just say the person in the car hadn't died. They could have said, fair enough, self-defence fails, but we'll give you a suspended sentence. Yeah? Or if a burglar's in your house, you go a little bit overboard, fair enough, self-defence fails, it was excessive, we'll give you 6-month sentence. So you can reflect the lack of culpability in the sentence, or it could be community-based or very low prison sentence. The problem is with murder, there is no lesser sentence. So even where you acknowledge that D needed to use self-defence, yet he's gone overboard, you can't reduce it to anything. So we'll come back to that in a second because there is a good suggested reform to get around that rule. But in short, under that question, number one, it's unfair. Number two, if it'd been any other crime, they could have reduced it massively. SD fails, but reduce the crime. But with murder, you've got no option. So in other words, even though we agree he really did need to use self-defence, the fact he went overboard makes no difference. Life. Right, so the second aspect to the objective test is relating to how objective the objective test is. So that seems an odd question to ask. How objective is the objective test? However, the courts, the Court of Appeal, House of Lords, have done their normal business, which is make an objective test not really very objective. So here we go. So the test today is as follows. Whether the force was deemed reasonable is to be judged by the jury, so it is predominantly objective. However, the jury must put themselves in D's situation. The jury should not disregard D's state of mind at the time. So that is law today. So it is objectively reasonable to the jury, but don't ignore what D is going through at the time. And don't ignore what he's seeing and his state of mind at the time. So really, in my percentage world, what we're saying there, that's a 90% objective test. Was it reasonable, knife against knife, gun against gun? Yes, according to jury. But just consider what D was thinking, what D was seeing. Was he being burgled? How was he being threatened? Etc. So, a couple of things to note then. First of all, the test then. So the test is objective, brackets 90%, but taking into account D's view and state of mind at the time. So the test is 90% objective, but taking into account D's view and state of mind at the time. 90%. I know you'd never use that in the exam, that's my percentage, but effectively that's what it refers to. 90% objective, but just looking at what D was seeing, his view and his state of mind at the time. So in terms of judicial reasoning, more so essay, just adding there White and Palmer, the Court of Appeal just elaborated on what we've just said above with two quotes, and it will look good in terms of linked case, judicial reasoning. So in terms of Palmer, so the Court of Appeal added that D will be unable to weigh up the niceties. Niceties is a funny word, I'll spell it Niceties. That D will be unable to weigh up the niceties of any situation and will act on instinct, and the jury should consider that. Just to put that into my own world, my own language. For example, if you're being burgled, you haven't got time to weigh up exactly who, what and why. What is he using? Is it a knife? Is it a gun? How much force is he going to use? How tall is he? How far should I go? D will never have the opportunity to weigh up the niceties, the detail of exactly what's going to happen. All that you'll do is you will act on instinct. Again, it brings it back to this flight or fright. So it seems good PP that the jury should consider that. R.V. White, same men, same judges, same Court of Appeal, added that the state of mind of D and D's view of danger is relevant to the objective test. Just different words to say exactly the same thing, in effect. That when you're deciding whether or not objectively the force is reasonable, add in the state of mind and add in the view of danger of D at the time. Both good PP. So from both cases of White and Palmer, Lord Lane stated that the state of mind of the defendant or the accused and his view of the danger may be relevant to the test, and so it followed on from that the test of reasonableness may not be entirely objective but merely largely objective. In other words, the jury should not disregard the state of mind of the defendant altogether, and that's why this test comes up at a 90% objective test rather than pure objective. So still in relation to the objectivity of the objective test, the case of Scarlett, the defendant was a licensee of a pub, a landlord, who asked a drunk man to leave the pub. Now the drunk man refused, so the defendant threw him through some swing doors, whereby the victim fell down the stairs and he died. It was held that the defendant was not guilty, not liable, as he could only be convicted if he believed that the force was excessive in the circumstances as he perceived them to be. Ultimately, what the Court of Appeal have done is reworded the test, reworded White and Palmer to impose a complete subjective test. White and Palmer had stipulated that the test is objective, i.e. was the force reasonable to the jury, just taking in that 10% account of what Dee was seeing and thinking at the time. This test was completely the opposite, i.e. did Dee think that the force was reasonable or excessive? Just a few notes to write next to the case. So number one, it imposed a 100% subjective test. And number two, the defence would always succeed. No defendant would agree that their force was excessive. Defendants would agree that their force was reasonable. So, bad PP in addition to that. So the next case, Owino, the defendant was convicted of assaulting his wife, causing injuries to the head and the thumb. And he'd claimed that he was using force in order to restrain her as she had been attacking him. The trial judge refused to follow Scarlett, and so the defendant appealed upon those grounds. The defendant argued Scarlett that he thought subjectively he'd used reasonable force. Court of Appeal reviewed what they decided in Scarlett and held that the test was not subjective but largely objective, i.e. did the defendant use objective, excessive or reasonable force. The jury must take into account all of the surrounding circumstances, including Dee's foresight and view of danger. However, the test remained largely objective. In short, the Court of Appeal have realised they've made an error in Scarlett, and they've rectified that error by returning to the test in White and Palmer. So just to summarise, the objective test originally was 100% objective, i.e. completely the jury's call. White and Palmer imposed a 90% objective test, just taking into account Dee's view of the danger and the state of affairs at the time. Scarlett imposed 100% subjective, and Owino has gone full circle and returned to White and Palmer, the 90% objective test, just taken into that small account of Dee's view of danger and foresight at the time. Now, so in relation still to the objective test, bearing in mind we are now looking at Dee's state of mind, therefore the question has arisen to the Court of Appeal attention as to whether psychiatric evidence of a mental illness will be relevant to the test, i.e. if Dee is depressed or Dee has a psychiatric illness such as schizophrenia, is that relevant to the objective test? The case which discussed this initially was the case of Tony Martin, very famous case which we have discussed in class before. This was the farmer who had been burgled almost 50 times. The police had done absolutely nothing in relation to these offences, and therefore the defendant was pretty much dismayed. So one evening he shot two burglars as they escaped from his property. So they were running away from his property, and self-defence did fail, which is his first defence in the first trial, because it was held that this was excessive force and self-defence failed. somebody running away from you and if you shot them, that is excessive, that is not reasonable force. In brackets, part 1 would also fail, there was no imminent threat. Now, the question was D's depression and paranoid personality disorder relevant to the test? Because if they were, then of course the objective reasonable man would have those same conditions. However, the defendant's depression and paranoid personality disorder were held to be irrelevant, even though those conditions meant that Martin believed he was in extreme danger. The force utilised was objectively excessive and unreasonable, i.e., in conclusion, his psychiatric conditions were not relevant to the test. So, question, what was the significance of this decision? Number 1, bullet point, D's state of mind is relevant still to the test, brackets 90% objective. But bullet 2, evidence of a psychiatric condition is not relevant. So state of mind is relevant, just not psychiatric conditions. Now, this ruling was recently confirmed in the case of Cans, and the Court of Appeal agreed with the decision made in Tony Martin's case. And the Court of Appeal agreed, and actually it kind of makes sense when you look at the bigger picture. And the Court of Appeal held that it would be wrong to add psychiatric conditions because it would mean the more psychotic the defendant was, the more likely that self-defence would succeed. So the madder the defendant, the more likely he would be acquitted. And of course that would not be good PP, dangerous people released back into society. So the most recent case on this point is a case of Oy, which was 2013. The defendant was a 29-year-old male who was discovered acting in a strange manner in a cafe. Now, the police were called and he was hid in the ceiling at the time, shouting very strange comments. At the police station, he attempted to escape, but in the events, assaulted 2 police officers, and he pleaded self-defence. The defendant was sectioned, claiming that the police officers were the agents of evil spirits. Now, the medical team confirmed that he had suffered a psychotic episode. He pleaded also insanity, which did succeed. However, self-defence failed, as his delusions were held to be irrelevant to the defence. So really what the case of Oy has done is confirm the previous situation of Tony Martin and the decision of Cans. So, self-defence and murder. So this is one of the biggest criticisms of self-defence. So has highlighted in Clegg, where D used more force than was needed, than was objectively deemed reasonable, D will be guilty of murder and the sentence cannot be lowered as with any other crime. However, the law recently changed due to the Coroners and Justice Act 2009, which covers DR and loss of control. So, question, how will the new legislation possibly assist a defendant who uses self-defence, needed to use self-defence, but uses force that is slightly overboard, excessive, unreasonable? The answer to that question is as follows. It may provide, the new Coroners and Justice Act may provide a defence to murder, a partial defence to murder, where D has a fear of serious violence from D, i.e. he's using self-defence because he is in fear from D. So what we're talking about here is trigger 1 within the loss of control defence. So as long as the normal person of D's age and sex would have reacted in the same or similar way, then where D has this fear from D, such as a burglarious situation, it may succeed even though they've used excessive force, so it might provide a defence to murder, i.e. reduce it to manslaughter and the possibility of a lesser sentence. So the type of defendants it may assist, privately Clegg, the case we discussed earlier, or where a defendant kills an intruder. So their force might have been deemed to be excessive, but now under the Coroners and Justice Act they have a defence, but a partial one, to manslaughter. Mistaken self-defence. So, mistaken self-defence, this is where D has utilised self-defence but made a mistake in the need to utilise that force. In other words, he didn't need to use force at all. So where the accused mistakenly believes he needed to act in self-defence, he will have a defence if he made an honest mistake and the degree of force was utilised in a reasonable way. So the test actually is completely the same. All you're adding is a couple of extra words. So part 1 is still, did D honestly believe that he had to use force in self-defence? That's exactly the same as normal self-defence. What we're adding on is the caveat that D must have made an honest mistake. It doesn't have to be objectively reasonable, but did D make an honest mistake? Test 1 is still subjective. All we're adding is those last few words. Number 2, was the degree of force reasonable, is exactly the same as normal self-defence. So actually the test is part 1 subjective, part 2 objective, exactly the same as before. All you're adding is those extra words, did D make an honest mistake, which doesn't change the test at all. So to illustrate mistaken self-defence, we have a couple of cases. Firstly, Gladstone Williams. So the defendant, whilst returning from work, he was on a bus and he saw a man punching a youth. So he questioned the man, he got off the bus, he questioned the man, who replied that he was arresting the boy because the boy had mugged an old lady. Then he added in the extra detail that he was also a police officer. Now, everything of the story that he retold there was accurate, apart from the fact he wasn't a police officer. So in fact, he was not an officer, but the remaining facts were true. As the man could then therefore not produce a warrant card, the defendant Gladstone Williams, who had gotten off the bus, attacked the man to save the boy. It was held that the defence could still succeed, mistake and force in the prevention of crime this time, as the defendant had made an honest mistake that the man was not in fact apprehending a mugger, although he was. He'd made a subjective honest mistake. The mistake itself need not be reasonable, it just needs to be honest. And when he got off that bus, he honestly believed he had to use force in prevention of crime. In addition, the amount of force used was reasonable. A grab against somebody punching a youth was deemed to be objectively reasonable. So the defence succeeded. The second case on mistaken self-defence is Beckford. So the defendant this time was a police officer who had received a call that his family were being held up and terrorised at gunpoint. The defendant shot and killed the man who ran out of his house as he approached. The defence succeeded as, number 1, he'd made an honest mistake that the man was armed. Now, it didn't need to be reasonable, but because of the phone call, the information that he'd been given, that it was an honest mistake. And number 2, the degree of force was reasonable, gun against a gun. Okay, the next section is mistaken self-defence and intoxication. So as above, we have just noted that mistaken self-defence can be successful. However, where D has utilised self-defence via a mistake and D is drunk or intoxicated or taken drugs, self-defence will always automatically fail for every crime. So this is a major AO2 critical area. Many academics have criticised this ruling as being harsh. So you haven't got a lot of space on the handout, but you just need to make some notes as to why this is harsh. Now, the normal law of intoxication, there are 2 different rules. One set of rules for basic crimes and a second set of rules for specific crimes. So intoxication - specific crimes the defence can succeed. So an example of a specific crime would be murder. So if you were really, really drunk and therefore had the use of the defence of intoxication for a specific crime such as murder, if you were so drunk that you failed to form the mens rea, it can succeed. However, if you are drunk or taken drugs for a basic crime, basic crimes are less serious crimes where the mens rea can be recklessness, automatic fail. So in short, normal law of intoxication, specific can succeed, basic, automatic fail. Which is good PP, because when people go out and get drunk and commit basic crimes, less serious crimes, they should never have a defence. It's what people do when they get too drunk. Specific crimes, you're going down normally for something like a life sentence, the intoxication has to be taken into account. So that's good PP. However, where D in this situation has committed an assault and committed that in self-defence via a mistake, if he is drunk, then it will automatically fail for both. Now, that actually is a major problem. What we've just said before is for specific crimes it can succeed. So let me give you an example to illustrate how this can be harsh. If D goes into a pub and there is a fight, an altercation, D is very drunk, he has a fight, and he stabs and kills the victim, intoxication can succeed. Now this is a defendant who's gone into a pub really drunk and started a fight, and intoxication can succeed. He is very culpable, yet it can succeed. I'll give you another example where D is less culpable, where it would now fail. If D was in his house and been burgled, D had had a few drinks before he went to sleep, and then D is found upstairs and the burglar is coming towards him. He's had a few drinks, but he is scared, he's been burgled, he throws the burglar down the stairs. The burglar hits his head and dies. Yep. Now let's just imagine that isn't a burglar. It's his next door neighbour who would let himself in with a key. What D has done is use self-defence via a mistake, but he is also drunk. Because the ruling is mistake, self-defence and intox is a complete fail, he would be liable for murder. So in other words, go out to a pub and get drunk, intox tick. The burglary situation, mistaken self-defence, life sentence. So it is very harsh. In effect, the law needs to be amended, or it's argued it needs to be amended, that where D uses self-defence via a mistake, whilst being drunk, for specific, it should be considered. So that would be consistent with the normal law of intoxication. We'll pick this up as well when we do intoxication. It's quite tricky, it's a little bit complicated, but it should make sense. So in the case of O'Grady, so this was just right next to O'Grady, this was a basic crime. So actually, self-defence was completely academic. Where you commit a basic crime, in this case manslaughter, automatic, no defence. However, so the defendant and his friend were drinking 8 bottles of cider and they both fell asleep. The defendant had explained that he woke up to find that his friend, who was also drunk, had been hitting him. The defendant picked up a glass ashtray and hit the friend back. Then when he woke in the morning, he found that his friend was dead and he was charged with manslaughter, which is basic. So D raised intoxication and mistake. The defendant's intoxicated mistake using self-defence failed as he'd been charged with a crime of basic intent, and under the intoxication law, which are called the Majewski rules, it's no defence. So just to add a couple of notes below that case, D had committed a basic crime, hence automatic fail. When you add in the mistake and the self-defence, it's a definite fail. For basic crimes, intoxication will always fail. However, the problem with this case is the obiter that was made by Lord Lane. So not binding at this point, but certainly persuasive for future decisions. And Lord Lane noted that intoxicated mistakes were not a permissible excuse for specific as well. Wow, very harsh. So fine on the facts, basic crimes, intoxication, via mistake or not fails, but for specific crimes, he's now saying that the defence will not succeed. So that was only obiter at that point in time. However, the next case came along via the Court of Appeal's attention. So the next case, in the case of Hatton, the defendant this time was charged with a crime of specific. So I would just note that next to the word Hatton. Specific intent crime, which was murder. So, very strange fact. The defendant drank 20 pints of beer and attacked and killed a man he had invited back to his flat. So it was just a random man that he'd met in a pub. Now the defendant claimed he couldn't remember anything of the events as he had been so drunk, but he mistakenly thought that the victim had attacked him with a 5-foot stick or a sword, he wasn't sure. Hence, he thought he was using self-defence at the time of the killing. The Court of Appeal picked up the obiter that had been made by Lord Lane. And the Court of Appeal held that an intoxicated mistake could not provide a defence for now basic or specific. The defendant was, as a result, convicted of murder. Really, really, really significant decision. This is now creating this inconsistency with intoxication. This is now saying that going to a pub, get drunk and have a fight, you can have a defence of intoxication for specific, but where you've made a mistake, automatic no defence. So it's inconsistent with the normal law of intoxication. What significant observation was made by Lord Phillips in this case? Lord Phillips made the note to the point that he did acknowledge that there was wide criticism of O'Grady, but then he still picked up the obiter and applied it. So that really doesn't make sense. If something is critical and being acknowledged as a problem, then just don't pick up that obiter. But that's exactly what he did. So he picked up the obiter and he applied it, which doesn't really seem to make sense or logic. Okay, so even though the O'Grady decision has been criticised heavily, it has been followed in the cases thereafter, for example O'Connor, which gives you a link case. So, question, how has the Criminal Justice and Immigration Act 2008 affected this ruling? Well, the answer to that is, strangely enough, the Act confirmed O'Grady and Hatton, so confirmed what I would suggest is bad law, in saying that mistake, self-defence and intoxication is automatic no defence for anything. Again, that still remains inconsistent with the rest of the criminal law in terms of intoxication.